Hey guys, Ryan Reifer here. Thanks for tuning in. Today we're going to talk about a question that I've gotten a couple of times from different folks, sort of just curious about it, which is what on earth is going on with the carbon monoxide in the Derek Chauvin trial. This is the cop who is alleged to have killed George Floyd and is currently on trial in Minneapolis with the jury deliberations scheduled to be next week. Before we get any further, go ahead, drop a like, subscribe, comment, send me a message if there's anything else that you want to see. Let's get started. As you probably know, I am a business attorney, right? I don't do any criminal law. Nonetheless, I have had a few people ask me, they don't have a whole lot of attorneys in their network, and they've asked me, what on earth is going on with this carbon monoxide thing, and why is the judge threatening to do a mistrial over the introduction of something about carbon monoxide, and what on earth is going on? So I figured I'd take a minute and sort of try to give you a baseline explanation here, right? And for a more detailed explanation, you're going to want to talk to a criminal attorney. But let me see what I can clear up. So from the get-go, what you need to know is that the burden is on the prosecution to show that the defendant is guilty beyond a reasonable doubt, right? Now, a lot of people remember from the OJ trial, Johnny Cochran, who was, to say fantastic would be an understatement, criminal defense attorney. And he put this phrase of beyond a shadow of a doubt in a lot of people's minds. That's not the actual legal standard. It's you must show every element of the crime beyond a reasonable doubt. Now, what's a reasonable doubt? Then you can get into that, but that's the prosecution's burden, right? As the defendant is presumed innocent until proven guilty, and the prosecution has to prove every single element of the crime beyond a reasonable doubt. Otherwise, the jury must acquit. Or to go back to Johnny Cochran, right? If the glove doesn't fit, you must acquit, right? Everybody remembers that one. Conversely, the flip side of that is that the defense's job, and this is true as in the Derek Chauvin trial, as in any other criminal trial, the defense's job is to sow doubt, is to create a reasonable doubt, right? So in this specific case, you have the prosecution trying to show the elements of murder or the elements of manslaughter. So Derek Chauvin had his knee on George Floyd's neck for 9 minutes, and he knew that was going to kill him. He did it intentionally, blah, 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 like that, and whatever elements may be required to be shown, that would be the case for murder, right? One of those elements is causation, which is to say that the thing that the accused did must have caused the death or injury or whatever of the victim, right? So if it was not Derek Chauvin's knee on George Floyd's neck that caused him to die, the prosecution must show that A caused B caused C, right? So the defendant's conduct caused ultimately the harm with which he's being charged. If that element of causation is busted, and that can be done by any number of things, then the defendant would presumably be acquitted because the defendant's conduct was not what caused the victim to, in this case, die. So to that point, remember, the job of the defense is to sow doubt, right? Is to create that reasonable doubt. They have all of these theories of like, well, hey, maybe it was this thing that caused him to die, and maybe it was that thing that caused him to die. They don't have to prove any one of those, right? They don't have to show beyond a reasonable doubt that it was carbon monoxide, or that it was a drug habit, or that it was that he was, clogged arteries and whatever. They can just throw this stuff out there and say, well, maybe it was this, maybe it was that. And if one member of the jury decides that, like, you know what, hey, I think it was really this other thing. I don't think it was the knee being on his neck for 10 minutes. Then you're going to have either a hung jury or innocent verdict or acquittal or something, right? You're not going to be able to convict. If one of those members of the jury says, hey, I don't think that this is what caused that, right? I don't think that A caused B. So that's what the defense is doing here, right? And so they pull up this expert on carbon monoxide and say, hey, look, these guys were close to like the tailpipe of the car or whatever. So like maybe the carbon monoxide, was what caused his heart to stop, and like, it didn't really have anything to do with the knee on the neck for 10 minutes or, something like that, right? If you can get part of the jury to think that, well, hey, maybe it was that, and they don't even have to say it definitely was. They could say, well, hey, maybe there's enough of a chance that it was. it's not certain that it was the knee on the neck, right? You just have to remember, you have to create that reasonable doubt. You don't have to prove that it absolutely was carbon monoxide. You just have to get a little bit of doubt in there, show like maybe it was. So that's the defensive strategy, right? Is to throw up all this stuff on causation, say, well, maybe it was this, maybe it was that, blah, blah, blah. To the specific point of the carbon monoxide, the prosecution got in a little bit of trouble with the judge, and the judge came about this close to declaring a mistrial towards the end of last week, because the prosecution had some evidence that was not disclosed to the defense that would have tended to show that, or I assume would have tended to show that it was not in fact carbon monoxide that did anything. And presumably you could measure the carbon monoxide in the guy's blood, or they had that blood test, or there's some sort of test that you can run. I'm not going to pretend to understand it. Doesn't matter here. The point is, the prosecution has to disclose all of that evidence that it's going to use to the defense, right? The prosecution can't just like show up later with evidence. It's like, oh, surprise, we have this thing. It's a legal requirement. It's part of due process. You have to show the defense what you have. So the judge damn near declared a mistrial because the prosecution, was sort of going to introduce this new evidence, and he said something to the effect of like, hey, if y'all reference this new evidence in any way, if you reference this test that you didn't give to the defense, then I'm going to declare a mistrial, and you're going to have to do the whole thing over again. Now, another brief little point before we go any further. My understanding from prosecutors and defense attorneys and folks I've talked to, folks from law school, folks I've made in connections over the years, is that generally a mistrial tends to favor the prosecution, right? So it perhaps could be in this circumstance interpreted as a victory for Derek Chauvin because he doesn't go to jail immediately. He doesn't get convicted of murder and go away forever, but he gets a few more months of freedom if a mistrial is declared. But over the long term, a mistrial, in most cases, and most experts say, mistrial it usually benefits the prosecution, right? Because they kind of know the defense's playbook at that point and can prepare for it a little bit better. So anyway, hopefully this explainer was helpful to y'all. Hopefully it gives you a little bit more. You can sharpen up your questions a little bit. Again, I'm not a criminal lawyer. This is a very, very basic introduction that just has to do with the requirements imposed by due process and kind of the procedural aspects of a criminal trial. So again, like and subscribe, really appreciate it. Any comments, any messages, etc. If you are already subscribed, go ahead and hit the little alarm button thing, and I think I'm gonna go it's on that side of the page, I think. I did it wrong last time, but I think it's over there. So thank you guys for watching, and take care, and any other topics you want to see, like I said.